Thank you so much. Whatever I'm going to say today does not necessarily, convey the official negotiating position of Government of India. It's purely from the legal researcher's point of view. So India is a large country. We have a huge population. So we have always had a debate on what constitutes development, or what constitutes environmental protection. So that hasn't been solved yet. Jumping into the bandwagon of protecting environment might not necessarily work for India. I'll come back to that later. There's a clear separation of power arrangement in India. We have legislature, executive, judiciary, completely independent from each other, having defined their own role. And India follows a quasi-federal structure where national government has larger power, state governments do have powers to a limited extent. In terms of implementing international environmental law, it's the Ministry of Environment and Forest, which is national government, does all sort of activities. Starting from 1974, when the Stockholm Conference concluded, where India represented by the Prime Minister herself, we started a series of legal enactments, starting with Water Act, then Air Act, EPA 1986. So we had a series of legislation from 1974 till 1992. That the importance of creating legislation was added up because of the Bhopal tragedy in 1984. So it really shook us, India, badly, because we never had the technical capacity to deal with such a large disaster, nor international community, where the parent company existed, never helped us in any sort of legal redress. Maybe because of the political turmoil too, we had several governments coming and going in the 80s and 90s. Legislative enactments was not made effective. It was never made effective. Because of that, judiciary played a prominent role in bringing the concept of environmental law and justice to the country. If you look at the decisions of the court, especially Supreme Court of India, most of the international principles have been applied because of the judicial decisions. Starting with polluter pays principle, to precautionary principle, intergenerational equity, reference to sustainable development, all came through judicial decisions. It's remarkable. Such a body of knowledge, such a body of jurisprudence has never been made effective in a short span of time, within 15 years. This incident, this development of international environmental law to India by the court has been criticized to a large extent. I'll come back to that again. In terms of administrative structure, the Water Act, which was created in 1974, created two agencies called Central Pollution Control Board and State Pollution Control Board. These two agencies are purely pollution related, doesn't have any policy functions, purely undertake administrative activities for Ministry of Environment and Forest. Heavy criticism again for these two bodies, largely underfunded, lack technical capacities, largely follow what the government wants. And if you look at, again, the court, starting from 1980s till 2000, there are specialized sittings in Supreme Court purely on environmental matters. There are several high courts in state which had environmental benches. So in effect, court played a major role in India to preserve and protect environment. One of the major decisions of court is on the concept of absolute liability. The government of India, Supreme Court, has gone one step ahead in terms of liability. The strict liability, which was normal practice elsewhere, was expanded to bring in something called absolute liability, where there was no exception in terms of liability. If you're an owner holding a hazardous substance, you're absolutely responsible, absolutely liable, no exceptions. This was again due to the Bhopal tragedy in 1984. And if you look at the public involvement and consultation, we have two remarkable legislation. One is the Freedom of Information Act of 2005 and the environmental clearance procedures enacted under Environmental Impact Assessment Notification of 2002. These two notification as well as the law of Freedom of Information Act provides public full information and transparent information regarding all projects and processes. I'll come back to to the reference to judicial activism in a bit. I don't know how many of you know that 1/3 of Indian geography is actually not governed by India, state of India. We have a huge tribal population completely against the government of India. And the criticism, which was recently referred by the Minister of Law and Justice, is that because of the 1984 judgment of the Supreme Court, which effectively banned felling of trees, the entire tribal belt actually left them no source of income. So I was really surprised in session 2, where there are two really passionate arguments on one is non-regression and second on environmental justice. Please be beware of environmental activism might lead to major social and state challenges. That I think one should be very clear about that. And second major initiatives which the government of India is recently taking is on two. One is the National Environmental Protection Agency, which effectively subsume all the administrative activities till date conducted by ministry and other CPCB bodies. And second, we are in the process of creating Green Tribunal Act, a specialized tribunals for environmental justice, environmental cases, which is actually passed by the Lok Sabha. Rajya Sabha has already passed. It's with the president. She might sign soon. I'll end up with that. Thank you so much.